Hello folks, welcome to the Edupedia world and I am Abhinay Gupta. Today we'll continue with the topic, the Sarfasi Act 2002. The detailed name of the act is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002. So far in this act, in the previous two lectures, what we have seen is the entire flowchart, right? We have linked the four basic elements of this chapter, which is the obligor, the originator, which is the bank, the securitization and reconstruction company, and the qualified institutional buyers. Right? We have seen how these components are interlinked and how the entire process goes about. Right? Then we had also discussed some basic definitions that have already been asked in your previous examinations. Right? Some of it being what is asset reconstruction, what is securitization, what is a non-performing asset, what is a financial asset. Right? These type of things have already been asked in your previous examinations. Right? You have been asked to explain them. So, and we have also discussed some other definitions that are important, which you need to know and understand from the point of view of understanding this chapter and also from your examination point of view. So far we have seen how the entire process goes, what the chapter is all about. We have seen the basic definitions, and now we move about with section 3 that talks about the registration of the securitization or reconstruction company. So, what are the basic two requirements if any company wants to operate as a reconstruction securitization company? Like, not all companies can do that, right? They have to be registered under this act. So the basic requirement for it is that that particular company needs to hold a certificate of registration under section 3 of the Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act 2002. Right? So one thing is you should hold the certificate of registration, which is given to you by RBI again in this case. Right? And then one other requirement is that if you are a new company coming into the market, then you need to have a net owned fund of greater than 2 crore rupees. Right? Because you will have to pay the bank the amount to get the asset and then start working on it. Right? So because this company is involved into financing and reconstructing of assets, so a basic capital is very important. So a bare minimum limit has been set, which is 2 crores. If you have 2 crore rupees, you can commence your job as a asset reconstruction company. Right? And if you are an existing company, right, the existing and doing this work, then to get the certificate of registration, you will have to have such percentage of the financial assets that you already hold. Right? Suppose you are holding a financial asset that you have purchased from a bank that is worth rupees 10 crores, right? And the RBI has asked you to maintain a capital fund. Your own fund should be that is involved in it should be, for example, 10%, and rest 90% can be borrowed from qualified institutional buyers and other investors into the market. And the maximum percentage that RBI can set a limit to is the 15%. Now, if you understand this, then what is the purpose behind this? If you are a company operating as a asset reconstruction and securitization company, and you have taken all the finance from qualified institutional buyers, given it to the bank, taken the asset, and now you go for reconstruction. And if you're not able to reconstruct, the qualified institutional buyers are at loss, right? So to secure those investors too, what the bank wants is that whenever you are purchasing a financial asset from any bank or any financial institution and then attempting to reconstruct it, then the maximum amount of loan that you can take from the institutions, the investment that you can take from qualified institutional buyers, from other institutions who are ready to invest, then you will not be allowed to take a loan above, say, 85% or 90%. That means you will have to involve some of your money in stake too, right? So you will also have to bear a minimal amount of risk, which can vary from 5% to 10% to 15% at max. Right? So that you operate and work elegantly and give into it your genuine effort to reconstruct the asset, right? Because even you will be at a fear of loss, right? So these are the two basic conditions, two basic requirements, that you need to have a net owned fund of either 2 crores or such percentage as directed by RBI, plus a certificate of registration. Now this limit that is set by RBI, which is a maximum up to 15%, can vary from class of company to other class of company and can vary from any company to other company. So it is the discretion of RBI, right? Whom to give what percentage, whom to allot what percentage, right? So it is not a uniform percentage. Like it's not like RBI gives out a notification that all securitization company will have to have to invest this much percentage of financial asset from their own fund. They'll have to have that much of own fund. That is not a requirement. RBI can specify for different classes of company a different percentage, right? And when you are an existing company before the commencement of the act, right? So when the act has commenced, you are already a company which is operating as an asset reconstruction company, but you will not have a certificate of registration under section 3 from the act, because the act was not enforced by the time you were already acting as a reconstruction company. So now once the act has come into force, right, within 6 months you will have to make an application. You will have to make an application for registration to the Reserve Bank, right? And that should be done within 6 months period from the commencement of the act. And in the meantime, you can continue with your asset reconstruction business unless and until you have been granted the certificate of registration, or you have been rejected the registration and that rejection is communicated to you. So until then you can continue as an asset reconstruction company, and then if you get the certificate you can continue it even further, and if you don't get the certificate and if you get a rejection from RBI, you will have to stop the business of asset reconstruction, right? So now we see what are the basic conditions that you need to fulfill for getting the certificate of registration. The holding of the fund is a separate issue. Now we talk about the certificate of registration and what are the conditions you need to fulfill to get that certificate of registration. So RBI, before giving you the certificate of registration, needs to be satisfied, right, that yes, you are worth getting the certificate of registration. And how is it satisfied? It is satisfied when the following conditions are being fulfilled. We'll talk about the conditions, right? And how does it get satisfied? It will refer to the books, inspect the books and records that you have, right, to get itself satisfied with the following conditions. Now let us see what are the conditions. First is that the company that is applying, making an application to the Reserve Bank for getting the certificate of registration as a securitization or reconstruction company, they should not have incurred any loss in the 3 preceding financial years, right? That means they are able to do their work of asset reconstruction very well. If they have purchased a financial asset from any bank or financial institution, they have been able to reconstruct it. No matter whether they have been able to reconstruct the entire 100% amount or 90% amount, whatever it be, but they are not at loss, right? So the amount they have paid to the bank to get that asset, they have acquired or they have been able to reconstruct more amount from the obligor, and also given the shares of qualified institutional buyers back to them along with the principal amount that they had borrowed, and also kept a share of profit with them, right? So if you look carefully into the statement, it talks about no loss in the 3 preceding financial year. That means even if the securitization company is working at a break-even point, they will be considered for granting the certificate of registration. Profit is not a compulsion, but no loss is a compulsion, right? Then by inspecting the books and records, the Reserve Bank also needs to be satisfied that the company who has sent them an application for registration as a securitization and reconstruction company is able to realize the financial asset that they have acquired. Like they have an adequate arrangement to do that. They have their people, they have their resources, they have their contacts in place and everything, right? And the track record is also giving a proof that yes, they have been able to reconstruct asset in the past, and they have the same arrangements continued with them so that they will be able to reconstruct assets in future too, right? So realization of the financial asset that they have acquired from the financial institution or the bank is very important, and RBI needs to be satisfied that yes, they are capable of doing so and they have adequate arrangement for the same, right? And they also need to be satisfied that these people, that this company will be able to redeem the investment of the qualified institutional, that they shall be able to pay periodical returns, right, and redeem on respective due dates the investments made by the qualified institutional buyers into the securitization and reconstruction company. Right? So these are the two things they need to see, that they have adequate arrangement for the same. Right? For redemption of investment and like paying the periodical returns, they need to be sure that even if they're not able to reconstruct the asset due to any unforeseen circumstance, they should have a backup so that they can pay back the money of the qualified institutional buyers. So if they have that backup, if they have those resources, okay, they are good to go, they are good to perform as a securitization and reconstruction company. Then the management of a company is very important, and when the company is so critical as being a securitization and reconstruction company, the management plays a very important role, right? Because they'll have to be very crucial and very shrewd with the realization of the financial asset. They'll have to take major steps, right, which has to be lawful too. So what they want is that the directors, the board of directors, the management who are handling the entire company should be professionally experienced. Now, by professionally experienced, we mean to say that they should be professionally experienced in the subjects related to finance, securitization and reconstruction. And they should know the laws, their limits, and what are the way out for them, what are the limits that they can reach to, right? What are the steps that they can take for reconstruction and securitization of asset, what are the formalities, right? And they should also be well equipped with the knowledge of finance. And now, to keep the company unbiased, right, and for ensuring a better management and better coordination, RBI also has to look forward to the fourth point, which is they have to be satisfied that the directors, the nominees of the sponsors and the associate in any manner with the sponsor or the subsidiary company, their nominees into the board should not exceed 50% of the population of the board, right? So if the board of directors constitute of 11 directors, then 6 of them have to be the directors other than the nominees, right? Because the sponsors who have given their sponsors to the company, or the associate to those sponsors or the subsidiary, should not have a controlling interest into the company, into the operation of the company. Next, RBI also needs to check that none of the directors should be involved in any offense, including the moral turpitude, right? That all of the directors, 100% of the majority, should have a clean check, right, in respect of any offense of moral turpitude. And then there is another basic requirement, that the sponsors that we have been talking about, that the sponsors of the securitization and reconstruction company should not be its holding company. Like the holding company of the securitization and reconstruction company should not be allowed to be the sponsor of the same, right? And otherwise also they should not be allowed to hold any security in any controlling interest into the company. So anybody who is holding any controlling interest into the securitization and reconstruction company should not be the sponsor of the company, right? That is the basic requirement that RBI wants to check before granting the certificate of registration. It will also see whether these companies have complied with the prudential norms that have been issued by the Reserve Bank of India. And also the guidelines that the RBI issues, they have complied with one or more of the conditions of that guidelines. That is also a basic necessity. So when all these conditions are satisfied and RBI has inspected into the documents and satisfied itself that okay, this company is performing well, they haven't had any loss in the past, right, and they have adequate arrangement for realization of the asset and also to pay back the investors in the scenario when they are not able to reconstruct the asset or there is a delay in reconstruction. So they are able to make their periodical payments, right? And then the management is into good hands. They are professionally experienced directors into the field of finance, into the field of reconstruction and securitization. And then the sponsors do not have a majority hold on the company. So less than 50% of the directors are the nominees of the sponsors or the associates of those sponsors or the subsidiary companies, right? And then the directors, all the directors, 100% of the directors of the company, none of them should be convicted with an offense of moral turpitude ever, right? And then there is another requirement that the sponsor should not be the holding company or any other company which has a controlling interest into the securitization and reconstruction company, and that the prudential norms are complied with and all the conditions of the guidelines issued by RBI have been considered, right? So if these are satisfied, then RBI would issue the certificate of registration to the reconstruction company. Right? So if we talk about the grant of certificate, if RBI is satisfied with the previous conditions that we have seen in the previous slide, if the conditions are fulfilled and RBI is satisfied, then it would issue the certificate, it would grant the certificate of incorporation, certificate of operating as a reconstruction company, the registration certificate. And otherwise, if it is not satisfied, or if any of the conditions are not fulfilled, then an opportunity of being heard would be given to the securitization and reconstruction company. Actually, the would-be securitization and reconstruction company. Right? And if they're able to prove to the RBI, because initially RBI has just inspected the records and the documents. Right? Now, if RBI, as per the records and the documents, feels that they are not able to satisfy any one or more of the conditions as specified in the previous slide, then RBI would give them an opportunity of being heard. And in that opportunity, if now they're able to prove that no, these conditions have been fulfilled and we will be able to perform very well, we have adequate arrangements and our directors are very good, then RBI would again consider and give them the certificate. Else, if even after the opportunity, if they are not able to satisfy the Reserve Bank of India, then the certificate of registration would be rejected. And if they were an existing company, as we have already seen, they would have to curb their working as a reconstruction company and would have to come to an end. Right? They will not be allowed to work as an asset reconstruction company any further. And then if the asset reconstruction or securitization company, they want to make any major changes, like change in the name, change in the location of registered office, change in the management and stuff, they will have to take a prior approval from RBI. And if RBI rejects any of such changes, then they will not be allowed to make such changes. Like if they want to change the management, they want to change the board of directors or anybody, they want to eliminate a director and bring in a new one. And if RBI is satisfied, okay, go ahead, I have no issues with that. The other director is also not convicted with an offense of moral turpitude, even he is qualified, even he has specialized knowledge in finance and stuff, then RBI may allow. But if RBI rejects, then they will have to continue with the same management. Even in the case of shifting the location of the registered office, only when RBI allows, they are allowed to shift. Otherwise, they will have to continue in the same registered office. Right? And same is the critical condition when we talk about changing the name of the securitization company. Right? And basically from this section, from the point of view of this section of this act, change in management would indicate the change in the management by way of transfer of the share or amalgamation or transfer of the business of the company. Like there are three conditions when we consider it to be the change in management basically. It's not just about the change in director or stuff. Right? And then whatever decision the RBI gives, that would be final. And the asset reconstruction and securitization company will be bound to abide by the directions of RBI. Right? So that is all about the registration, the working, the conditions. Right? And once they have the certificate of incorporation, they will be good to go with continuing the working of the asset securitization and reconstruction company. Right? So that will be all for the lecture today. We'll continue with the next topic in the following lectures. So until then, this is Abhinay Gupta signing off. Thank you. Bye-bye.